Your Excellency, Sir S. W. Tapley Seaton, CMG, CVO, QC, JP, Governor General of St. Kitts and Nevis, the Honorable Anthony Perkins, Speaker of the National Assembly, Your Lordship, Dame Janice Pereira, Chief Justice of the Eastern Caribbean Supreme Court, the Right Honorable Sir Dennis Byron, Chief Justice of the Caribbean Court of Justice, members of the Federal Cabinet, other members of the National Assembly, the Right Excellent and Right Honorable Sir Kennedy Simmons, National Hero, and Lady Simmons, Justices of the Eastern Caribbean Court of Appeal, resident pristine judges, Ms. Janine Harris-Lake, Registrar of the Court, Ms. Melissa Fleming and Mr. Azad Gums, Deputy Registrars of the Court, Her Honor, Mrs. Josephine Malilu, Senior Magistrate, other members of the Magistracy, Queen Counsels and Senior Attorneys at Law, Ms. Delia Rowe, President of the Bar, Mr. Thaddeus Antoine, President of the OECS Bar Council, distinguished members of the Diplomatic and Consular Corps, distinguished awardees and their guests, members of the media, ladies and gentlemen, good evening. Firstly, allow me to bring apologies on behalf of the Honorable Prime Minister, who is unable to be here with us this evening. It is a distinct honor and privilege for me to address you all tonight as we commemorate the 50th anniversary of the Eastern Caribbean Supreme Court, ECSC. It is very fitting that we celebrate the past and embrace the future of the ECSC, particularly because legal luminaries from St. Kitts and Nevis have played a leading role in its administration of justice and are sure to continue doing so in the years to come. There have been either 12 acting or confirmed Chief Justices since the ECSC's establishment following the West Indies Act 1967. Notably, 4 of them, or 1/3, have come from St. Kitts and Nevis, giving the Federation the distinction of having the most Chief Justices named to the ECSC, namely Sir Maurice Davis, 1975 to 1980, Justice Neville Berridge Acton, 1983 to 1984, Sir Dennis Byron, the longest-serving Chief Justice, 1996 to 2006, who was confirmed in the position in April of 1999, after acting as Chief Justice in the first 3 years, and Sir Hugh Anthony Rollins, 2008 to 2012. St. Lucia and St. Vincent and the Grenadines tie for second, having had 2 legal luminaries from their country serve as Chief Justice. Grenada, Jamaica, Dominica, and the British Virgin Islands have each had 1 Chief Justice. This is a remarkable achievement by St. Kitts and Nevis, which once again proves that we do have remarkable talent and human resources, and of this we really should be proud. The establishment of the Eastern Caribbean Supreme Court by the West Indies Associated States Supreme Court Order number 223 of 1967 ushered in a period of momentous changes in the lives of our people. That year witnessed new and extraordinary opportunities for us to assert and challenge ourselves, having then entered into a new status of association with the United Kingdom in accordance with the West Indies Act of 1967. Fast forward 50 years, This beautiful federation of St. Kitts and Nevis stands fully fledged and independent, just as the Eastern Caribbean Supreme Court does. We have made our way here tonight to celebrate the evolution and achievement of the august ECSC over the past 50 years, and in so doing, I encourage all of us to consider its ineffable impact on our societies. Across the societies of 6 independent states, including St. Kitts and Nevis, and the 3 British overseas territories that it serves, the ECSC works diligently to uphold its motto, Fiat Justitia. This Latin phrase means justice be done, and is part of a legal saying which states, let justice be done though the heavens fall. In essence, justice must be done regardless of the consequences. This recognition of the preeminent role that justice plays in anchoring the fabric of society and ensuring that it does not rip to shreds has been espoused by the very wise philosopher Aristotle, who said, at his best, man is the noblest of all animals. Separated from law and justice, he is the worst. Nevis's very own Alexander Hamilton also espoused the humanizing and stabilizing influence of justice. Hamilton, who immigrated to the United States and became one of its founding fathers and its first Treasury Secretary, said, I think the first duty of society is justice. Early in his law career and in his late 20s, Alexander Hamilton took on the Rutgers versus Waddington case, which, on its face, concerned a dispute over back rent for a burned-down brewery, but became a landmark case for the U.S. justice system. Rutgers versus Waddington is now seen as the catalyst for the origin of the judicial review system. Judicial review of legislative acts is a cornerstone of good governance, which my government fully supports. Judicial review gives the High Court the power to assess decisions on their lawfulness and fairness. Essentially, the judicial review system gives the High Court the power to declare legislative acts as invalid if they are in violation of the Constitution. My Team Unity colleagues and I have applied a number of times for judicial review on the matter of the Boundaries Report, for instance, so our administration will always respect and accept the independence of the judiciary. Alexander Hamilton has also been credited for instituting new principles of due process. I have highlighted Alexander Hamilton's contributions to the legal field, not simply to inspire you to read the groundbreaking legal case, if you haven't already, but to reinforce that a citizen of this small, beloved country of ours has made, can make, and will make significant contributions to important spheres of life, such as the law here at home, regionally, and internationally, just as 3 of tonight's honorees have done, namely the Right Honorable Sir Dennis Byron, who assumed the post of permanent judge of the United Nations International Criminal Tribunal for Rwanda in the mid-2000s, and also served as its president for 2 consecutive terms. Sir Hugh Rawlins, who was appointed a judge of the International Administrative Appellate Tribunal of the ILO in Geneva, Switzerland, and Mr. Theodore Hobson QC, who last year became a Medal of Honor recipient for his contributions to law and remarkably was admitted to the bar of St. Christopher and Nevis on November 12, 1963, 4 years before the genesis of the ECSC. A superior court of record for the organization of the Eastern Caribbean Court, a superior court of record for the organization of the Eastern Caribbean states, the ECSC has ruled on a number of landmark cases. One that quickly comes to mind is the landmark cyberspace case, as it is called, which was presided over by the Honorable Mr. E. Anthony Ross, QC, who grew up just a stone's throw away from here in St. Johnson's Village in St. Kitts, I proudly add. The case out of Dominica tested how much freedom is allowed on the internet and was the first case in the jurisdiction to find defendants liable for defamation in cyberspace. The learned QC ruled on September 23, 2009, that the plaintiff was entitled to damages in the amount of EC $525,000, which was the highest award given to a claimant for defamation in the Eastern Caribbean Supreme Court. This precedent-setting case has surely made a significant contribution to the legal annals. As I wrap up, I extend sincere congratulations to the Eastern Caribbean Supreme Court on reaching 50 years, and I congratulate all of you who work in and conjunction with our justice system. I want to implore you to keep upholding that motto, fiat justitia, and let justice be done, and let justice be blind. To class and social differences, to illnesses, to physical features, and all the other trappings that are wont to distract. In ending, I turn to a matter that is dear to our Prime Minister, lead head for human resources, health, and HIV/AIDS. St. Kitts and Nevis just commemorated World AIDS Day 2017. Yesterday, we were among 5 other Caribbean countries to receive our dual validation certificate to mark the elimination of mother-to-child transmission of HIV and syphilis. While this is a tremendous accomplishment, we must not rest on our laurels. As Sir Dennis noted during a ceremony this September hosted in Georgetown, Guyana by the Pan-Caribbean Partnership Against HIV and AIDS, PANCAP, there is still some progress to be made in the Caribbean on the stigma front. Noting that the judiciary is the guardian of the due administration of justice and protector of human rights, Sir Dennis said that judicial officers are expected to eschew discrimination. There is no room for discrimination in the courtroom, he said, but there is more room for knowledge of the law as it pertains to HIV/AIDS, as well as the issues that play a role in the spread of the disease, such as gender equality. As CARICOM's lead head for human resources, health, and HIV/AIDS rests with our Prime Minister, we in St. Kitts and Nevis completely endorses Sir Dennis's perspective and vision. Sir Dennis, the President of the Caribbean Supreme Court of Justice, staunchly advocates that the court ought to promote confidence in the fairness of the judicial system and its administration of justice by improving access to and quality of justice for all. To this end, Sir Dennis strongly believes that the court's reach should extend beyond its precincts. This, he says, is necessary to protect people who are susceptible to discrimination, such as people living with HIV/AIDS. Tonight, as we look to embracing the future, let us be cognizant that we need to embrace change as well as each other. Let justice be done, and let it be blind. May it please you.
Stay up to date with news, programs, and activities of the government with SKNIS. Like us on Facebook. Listen to us on SoundCloud. Follow us on Twitter. And watch our videos on YouTube. Connect with us today. SKNIS, St. Kitts and Nevis Information Service.